Right. So we were just talking about the our responses, how we respond to this, to assessing the risk of fraud. So now, of course, it's the procedures. And again, you can, to be honest, again, AEIOU is your general guide in terms of thinking about this. But of course, this almost does feel like a specific engagement when it comes to fraud. It's not. It depends on on what system we're talking about, of course, isn't it? Because of course we have you could break it down into sort of a sales system and a purchases system and a wages and an inventory and a cash system, a non-current asset type register system. So the question here is, where is this fraud? And depending on the system, you will be carrying out this sort of AEIOU analytical type thing to look for fluctuations in the relationships from one year to the next. But again, inquiring of everything in effect. And if you can observe, it just is, where is the fraud? So this is some general ideas, I guess. It's really trying to understand what journal entries. Typically, frauds are general journal entries. Typically, that's not always the case. Depending, are we talking about a misappropriation of assets? Or are we talking about fraudulent financial reporting? So the question is, we're trying to identify where that manipulation of figures is going on. And of course, inquiring of those involved in the FR about that unusual activity. Maybe is it a management override? What's going on? Typically, you will see journal articles and journal entries and adjustments made at the end of the reporting period, and to sort of manipulate this fraud. And a number of things. Again, like I say here, it's really looking at those judgments that have been made, if you like, and if you in arriving at those figures. Typically, when you do a cash review, when you're testing bank and cash, you're looking for unusual transactions or transactions that are slightly outside the normal course of what we do. If you like, if a business is suddenly paying out to a certain so-called charity or paying out unusual amounts that aren't to do with suppliers or wages, or the question here is, who are you paying these amounts to? Again, remember that, again, we might have, who knows, we might be bordering gradually into the question of money laundering, but the question is just being awake. Is it a payroll fraud, and you want to investigate again to the original source of those contracts. This one is, again, a weak form, but it's important because this means that management are very aware that whatever they tell you, they are responsible for if anything is found later on. So it's obtaining written representation that they have acknowledged responsible for internal controls, if you like, that they've told you everything they know, disclosed of any fraud they have had in the past or recent past, and any allegations of fraud, or if there's anything right now happening with their lawyers right now relating to fraud. If you do find something along those lines, again, the process remains the same. You want to, of course, discuss with management and discuss with those charged with governance to sort of understand what's really taking place. Of course, now because there's a fraud involved, it really has to be a question of seeking legal advice, because the question here is, are we going to bring in the police? How is this going to be investigated? How material is this fraud? Of course, it will be disclosed, but the question here is in terms of materiality. How material is it? Is there a need for potential voluntary disclosure? And what is the impact on the report? Of course, this will again depend on the matter of disclosure, because you must, of course, it makes sense to disclose of this fraud to stakeholders. Again, kind of coming back to this question of withdrawal, we may wish that we don't want to relate with this business anymore because of the fraud, and so we see some sort of doubt over management integrity. So as usual, our lawyers, our legal department will be involved, and we want to sort of call a meeting to sort of let the shareholders and stakeholders know why we no longer wish to be involved. This is a classic accounting case. I think it's the kind of case that if you mention it when it comes to talking about fraud, you're doing yourself a great favor. It shows that you're aware that a lot of these ideas are kind of structured within cases, within case law, where you had this sort of judgment by the sort of the judge sort of saying or enabling auditors not to be held responsible for being sort of people who go in there to look for fraud. It's a very popular phrase that accountants or auditors, if you like, are watchdogs, if you like, and not bloodhounds going in there. So really, it does shift responsibility again to, if you like, to management, to implement policies and controls to prevent fraud. A couple of things generally. This question of knowledge. There seems to still be this expectation that we can go in there and provide absolute assurance. We cannot provide absolute assurance. We cannot tell you that for sure the assertions being made are 100% by the very nature of the accruals concept in the preparation of accounts. Judgments have been made, and because we take a risk-based approach to our testing, we cannot test everything. I mean, especially now we are in a much more digital age. Imagine very large businesses. You will always have errors, gentle errors, which is why the question of materiality is important. So we use judgments to decide in the period of time we have to come up with some kind of general agreement as to the value in the financial statements as to whether or not we can trust them. So there are limitations there, and of course we use sampling. So all of these are issues to think about. Right, we're just going to talk about what our legal liability is in terms of with regards to our clients. Typically now this has become an issue because, of course, if we are negligent, we need to. It is possible for clients to sue us, if you like, to sort of say that you didn't do your job well enough, and so we want some compensation. So really, what we do, of course, is to state very clearly within the engagement letter what our duties are, what we're responsible for. From an ethical point of view, we must carry out our work to the best of our ability. So making sure we have the best people on the job, or able people on the job, to professional competence, and carry out our work with due care, comply with our own professional standards and ethical requirements. I bring up this case because this is a very popular case where this company called Asset Co. Sued Grant Thornton for negligence. I believe the story is here. Let me just pick that up. This is a good story to highlight this point. So you can see it does happen. Auditors can be sued. And in fact, Grant Thornton actually lost this case and appealed and lost the appeal as well, because Grant Thornton was deemed to be negligent. So you can see here, it says here, so in 2017, the Financial Reporting Council fined Grant Thornton $2.275 million, and actually banned one of their partners, and after identifying widespread and significant failings in their work. So just picking up this, they tried to appeal. So it said Grant Thornton appealed against an earlier ruling by the High Court, which found its auditing of Asset Co to be a flagrant breach of professional standards, exhibiting failures of the utmost gravity. And I think the point here was that Grant Thornton failed to carry out. Grant Thornton admitted that it had, in important respects, carried out the audit in breach of its duty, failed in duty to identify management fraud, particularly dishonest representations and evidence provided to it by senior management in the course of the audit. So in of itself, written representations aren't enough. You still have to carry out procedures to try and identify, if you like, fraud. And so on the one hand, we are not bloodhounds, but you can see here that the judge and the courts found in favor, if you like, of the defendant, of the plaintiff, sort of arguing that they had a right, if you like, to sue and to get this money from Grant Thornton because decisions were made based on that those mistakes by Grant Thornton. And yeah, so there you are. So again, this is recent, in fact, because this was as recent as can't remember. This was in the news recently because the appeal itself is recent. Again, the point here is this appeal against this negligent audit. So the key point, again, just to bring the key point here, is that it is possible that you can be sued. So so I guess the first question really then becomes then how do auditors deal with this? And so the argument here is that the fundamental argument here is with the audit itself, you have a relationship with that client. So you have here. So typically what you now see people doing is in the engagement letter stating the a sort of liability cap, sort of saying that, listen, if there are any issues, put here the liability cap. If there are any issues, you can only sue us up to a certain amount. Now, the next issue becomes this question of third parties. So can an entirely different third party use this information and bank on it? So for example, which is why you now see audit reports saying that, listen, this information is purely for the use of the shareholders and, if you like, the directors. So this is to sort of prevent that, having third parties claim that they use the information, they use the audits, they use they relied on the financial statements and trusted the auditor's report. So what you now have is this situation where the burden of proof is on the, if you like, the plaintiff to say that they have suffered loss as a direct result of the defendant's breach. So the defendant being the auditor, and then the defendant owing a duty of care. So you have this. You need to prove that that somehow that the auditor had a duty of care towards you. And that's really the first point. The critical matter is, can you prove that a duty of care was owed? So I guess really the question is, what is this question of duty of care? So typically, again, the way of looking at it is saying that, well, would the auditors have known, or ought to have known, that the audit financial statements would have been made available to, or would have been relied upon by a particular person or class of persons? And there is a case, of course, to support this, where the auditors knew that the bank would be relying on their audited financial statements, and the banks did give or extend overdraft to this company, and the company failed. And so in that regard, the auditors were held liable. So the question here is, again, like I said here, the injured party must therefore prove that the auditor knew or should have known. The injured party has sufficient proximity, so belongs to a class likely to rely on the financial statements. So again, like I said, like bankers, and the injured party did in fact rely, and the injured party would have acted differently if the financial statements had shown a different picture. Then, of course, it is up to the auditors to prove that they had, if you like, carried their work out with up-to-date professional standards and ethical requirements, and complied with the terms, and employed competent staff who were adequately trained. So we will be looking at quality control, I think, in the next chapter. But the point is that you have that burden of proof, and you also have the defendant having to show that they had done the best they could. And this, because their job is not to find fraud, but their job is to, within materiality and good judgment, there you are. So really, of course, this is just a process. It's 14 minutes. So what we'll do is we'll take a break, and in the last video we'll finish off on this sort of more clearer point.